For nearly the last hour, you've been given an illustration as to what reasonable doubt is versus what it's not. And when all else fails, it's pretty simple. Blame the victim. Blame Christopher. That's the solution. His shirt says everything you need to know. Seriously? We're going to blame him? We're going to say that he deserved to be stabbed 5 times? We're going to blame Hosanna? And the simple answer from the defense was yes. This is supposed to be a truth-seeking process. And it resorts to blaming him. And it's not supported by anything, using reason and common sense. And your life experiences. Now, we know that the elements of murder in the first degree, in large part, are satisfied because of the simple aspect of self-defense. We know the defendant got caught after hiding for a month, playing hide and seek from police. No calls, nothing. After burning his body to cover it up. And we know that she acted intentionally and after deliberation. Now, ladies and gentlemen, you have the instruction number 13. If you need to go back to it, you can. And in instruction number 13, that lays out the law for you on the mental states. You heard the defense get up here for the last hour and talk about planning, and that word does not exist in that instruction. Look for it when you go back. Exercise of reflection and judgment concerning the act. Never one that's hasty or impulsive. But it doesn't require planning. It doesn't require premeditation. It requires an appreciable amount of time. Doesn't have to be long.
Objection, misstatement of law.
All right, can the parties approach?
And that anytime you're back there and you're discussing something that's vague, or you're speculating, or you're imagining, that's not what we're dealing with. What we know is on October 3rd, 2021, the defendant was guilty of first-degree murder at the time of the arrest. The defendant is guilty even without Hosanna Varela. And I want you to think about that in looking at words and actions. In light of your observations and experiences in life. Go back to the day that you were selected when you knew none of the facts prior to opening statement. And if you would have been told that this person was turned into that, with that in his neck, after being stabbed 5 times, using your reason, your common sense, hearing that his phone was taken, you still would have found the defendant guilty of first-degree murder. You would have heard the autopsy reveals this blunt object, where a handle is on one side of it, and a blunt portion is lodged so far in his neck that it has to be cut out during an autopsy? You would have found the defendant guilty of murder in the first degree based on those facts. The method of the killing, the manner of the killing, the number of the stab wounds. If you would have just heard from Dr. Burson as it pertains to how this weapon was and that the blunt end was lodged in his neck, and the degree of force, the effort, the intent, the purpose, those are the hard facts that you would have. The fact you would have to know and hear from Dr. Burson that you did, even without Hosanna Varela. The amount of trauma to his neck. What other picture could demonstrate to you a person's intent and their deliberation? And that's one of them to a carotid artery. And there are 4 others in a very small region of a person's neck. And then you would have heard that before the fire, everything is laid out on a bed with an open ring box. Where the victim's dad would have to discuss that ring. And then we hear specifically how we got there in this Chevy Malibu and connecting it downtown. And you can consider the fact that the defendant would have got up and still said to you, I don't really know cars, makes, and models. I don't know Chevys. I don't know Malibus. And you'd have the objective evidence that they take this, they come back, they light it on fire, they switch cars. That all of this goes back to the defendant. All of it. That's the evidence you would have had without Hosanna Varela. And you would have convicted of murder in the first degree right then. And you still should. But now this has morphed from a whodunit, once they get caught, and Miss Rodriguez knows she has to pivot. And she has everything on the line. And you are able to look at the credibility instruction. And specifically, that credibility instruction is number 7. think you should look at it. Because you have an immense power in this case, individually and collectively, that you are the sole judges of credibility. And what does that mean? You decide what you believe. You're to consider all the testimony and the circumstances in which they testified. Consider that person's knowledge, their motive. Who has the most motive, ladies and gentlemen? The defendant. State of mind, demeanor. You watched her testify. How would you describe that demeanor? And her manner while testifying. The strength of that memory at different points. Think back, go back to instruction number 7 when you are deliberating. I will be shocked if you believe a single word out of the defendant's mouth in that rehearsed testimony that was like a theatrical play with a systematic order.
And I'm sorry, Mr. Pirragliam, I couldn't hear the objection.
Can we approach, please?
Yes.
And so when we get into self-defense, it's pretty simple. You have to be convinced that the defendant was a reasonable person, that she took reasonable actions, and what you're provided on each of the self-defense instructions is this language. Specifically, that the reasonable person standard requires the defendant to appraise the situation as would a reasonable, sober person. The defendant was neither reasonable nor sober on October 3rd. And each of you have to take that into consideration. And so if you decide, well, maybe she overreacted because of the alcohol, then that's not self-defense. Had she not been so drunk, she might not have acted that way. She put this booze in her body. She doesn't get the benefit of then using it as an excuse. So let's talk about credibility of the other witnesses, and specifically what's been laid out by Hosanna Varela. She stated Chris was given vodka versus water. Ladies and gentlemen, this was a setup for Chris. She stated that Chris never had this weapon in his hand. The defense today wants to talk about this file that's been described throughout this time, where it's used for sharpening knives, or it's a file for other things that has this handle. They want to call it a shiv today. But ladies and gentlemen, think closely and clearly. How would self-defense have been detrimental to Hosanna Varela? What motive does she have to lie if she's trying to run out of this house and she gets pulled back by this man and her girlfriend defends her, saves her? If that was the truth, why would she not do it? Why would she write later that she witnessed this horrific murder if it didn't happen that way? She said there were no threats whatsoever to hurt them or to kill them. Again, ask yourself why. That no physical force was ever used against either of them. And that Mr. Dickerson was yelling for them to leave, that they could have left, that Ms. Varela was asking them to leave, and they didn't. And so, ladies and gentlemen, when you look at that, just there, that supports direct evidence and circumstantial evidence throughout this case that shows this wasn't self-defense. She said she wasn't afraid of being hurt. She gives the progression of Mr. Dickerson being hit with these beer bottles twice. That she again asked the defendant to stop, that they should just go. But most important, ladies and gentlemen, there was no need to kill him. How do you overlook that? You simply can't. Because true self-defense, where someone is taking another person's life, requires that necessity. No other options. And it's simply not here. You have the progression.
So she's pretty quick now. Is she on top of him, or where is she at?
I don't think she's on top.
Okay, so she's standing. She's kind of standing, and then Chris is on the couch.
Yeah, and I think he's trying to get up. I don't know.
Okay.
But and then she grabs the beer bottle and goes to hit him, but she misses. And I go, no, don't. I go, let's just leave it. You know what I mean? Like, let's go. And she looks at me, and she I think she grabs another beer bottle, has that same one in her hand, and then that's when she hits him on the head, and gets another one, and then hits him again, and there's blood and blood on his face and like everywhere on him. And
okay, let me.
Again, if that wasn't true, why would she say it? If Mr. Dickerson deserved to die, was threatening them, trying to kill them, that would have benefited Hosanna Varela. It would have benefited Hosanna. It would have benefited the defendant. Two birds, one stone. And you need to look at that using reason and common sense. And so, ultimately, you're going to be able to go through the instructions. I'm just going to highlight some of them for self-defense. But here's what you need to know of where we're at. The burden of proof always rides on the prosecution. And when the defense is claiming self-defense, they're admitting to the act, and therefore it becomes the prosecution's burden to disprove one element of self-defense. And you should each know that if the prosecution, and when we disprove one of those elements, you are to return a verdict of guilty. And each of you can decide which one you believe the prosecution has disproved. You need not all agree on the same one. So, for example, some of you can say right away, I don't believe that it was a reasonable amount of force. I don't believe that there was actually imminent force that was happening. So if you don't believe that it was reasonable, you're done. You sign guilty for first-degree murder. And so, with the fact of Hosanna Varela, if you believe Mr. Dickerson never had that weapon, which there's nothing to support that he did, The defendant had absolutely no injuries any which way, never calls police. What evidence is there that he ever possessed that weapon? There's no physical evidence. And then the testimony from Hosanna supports that. He never had the weapon. He never threatened them with the weapon. He never was going to use it. Imminent. Common definition. It had to be then. It had to be now. And we know from the progression of Hosanna Varela that there is this sequence of events with the throwing of the beer bottle, the smashing of the beer bottles, and now the defense talks about, yeah, we admit to arson, but you would have been able to see it on his head even though they burnt it beyond recognition so that they had to be identified by dental records. Ask yourself why. But if you don't believe that one, let's just go with the fact that there had to be a reasonable belief that a lesser degree of force was inadequate. Think through that. A reasonable belief, a reasonable sober person's belief, that you needed to plunge this file into his neck 5 times. That had to be necessary. So if any one of you right now is thinking, yeah, I don't think that was necessary, I don't think that was reasonable, the people have disproven that element of self-defense. And then it had to be an appropriate amount of force. You have to believe that everything that you saw during that autopsy was appropriate.
Objection, misstatement of law.
All right, I'll overrule the objection.
Was there a prong 3? Is there a reasonable belief that there was an imminent danger of being killed or receiving great bodily injury? Hosanna Varela makes that pretty clear. That during this progression, she was asked to retrieve the weapon. She was asked by the defendant to retrieve this weapon. That she heard the stabbings, that she saw Chris bleeding to death, and that after the defendant moved him to make it look like self-defense. She's then told to go out to the car, sees the items that were taken by the defendant. They drive off to the gas station, they return, and that she stayed in there. And so you should look at all of that and say, what is the motive for that? And how is that consistent with self-defense, and how is it inconsistent? Why admit to what you did, what you didn't do, if that's not the truth? Prong 4. People have disproven self-defense if you believe that the defendant provoked this. And I think there's ample evidence of that for you. And then prong 5, that is probably one of your easiest ways to disprove this, is decide on your own, who do you think was the initial aggressor here? And you get to look at all of the actions after, you get to look at the evidence of flight, you get to look at the evidence of arson, and the defendant's multiple statements to a variety of people, all for what? Now, there is this discussion of Hosanna being this mastermind. And essentially, you do have to find her to be so incredible at convincing you of something that she is a mastermind. And you have to think about the motive that she had throughout this process. And I will preface this with, if you have a hard time believing this, if you have a hard time and you get lost, if it seems unreasonable or crazy or far-fetched, then good. That means you're acting with reason and common sense.
Your Honor, objection, disparaging counsel.
I'm sorry?
Disparaging counsel.
All right, I'll overrule the objection.
You have to have an opinion that Hosanna has this motive to just completely screw over the defendant above all else in this world. And that she has to know that on October 3rd, 2021, she witnessed a justified killing. A killing out of self-defense, knows that Stacy did nothing wrong, but that they have to keep quiet about it. And she has to avoid going to the police to describe this lawful justification of deadly force. She has to accept that she just sat in the car while the defendant burnt this down and not act on that. She has to prepare notes in her phone detailing her depression, her struggle with her families, witnessing somebody get murdered, how that's impacted her, threats to her family, all things that no normal person would ever do or want shared in front of a group of strangers. She then has to wait to be arrested just to lie to officers that this is part of her master plan, eventually, that she's going to reveal to you and convince you. She has to also count on when she's arrested that Stacy's going to deny it, even though both women at that moment on November 11th know this was completely justified. She's got to make calls to Javi about being arrested, being clueless about bond amounts and first-degree murder. And despite all this pressure on her of trying to get out for her kids and wanting to go back to her kids, that she's got to wait in custody for 247 days. And then still during that time period, care more about screwing over Stacy than getting out to her children. And then she's got to write these notes while she's sitting in jail before her proffer with all this information that she knows she's going to reveal to law enforcement. And then one of those notes has to specifically be to don't hear or see or do anything, knowing that if she came forward that she actually saw, heard, and did everything in a lawful way, that she wouldn't be charged with first-degree murder, and neither would the defendant. She's got to go to this proffer. She's got to convince this seasoned detective of over 10 years who's able to corroborate her story throughout it. Even though she's saying she saw parts, she didn't see others, she heard parts, she didn't hear others. And then she's got to keep going with this ruse and accept a sentence of 16 to 32 years to be sentenced by this judge for 32 years, a sentence that's longer than her life and her oldest child's combined, all to screw her over. And then she's got to be brought back. And that's really where it gets fun for her, because for 3 days she's going to be questioned in front of you, and she has to convince you guys. And that's all part of her plan. You get to decide the credibility of that. You get to decide how she's supported by or contradicted by that. And you get to look at her and see that mastermind.
You're under arrest for first-degree murder, arson, burglary, and tampering with the deceased body. Okay? All right, that's what you're being charged with. Stacy's being charged with that as well, too. If you want to talk to me, I'll talk to you about it, and I can understand what happened that night. Okay? It's only if you want to. You don't have to. If you want to talk to me, I'll listen to your story. I'll always listen to people's story.
Yeah.
Okay? Is that something you'd like to do, is talk to me?
Yeah.
Okay. All right.
Can we talk like
We're going to talk at the station.
Okay.
Okay? Away from everybody else.
Okay.
Away from Stacy.
okay?
Is that something you'd like to do?
Yeah.
Okay. All right. I'll hear your story.
Yeah.
Okay?
Look at her quivering. Look at her look back. Can we talk away from... And who does she look back at? That's picked up by Detective Burrows. Yeah, we'll talk away from Stacy. Compare that to the defendant.
Maybe get out of the wind just a little
Yeah.
bit.
Can you put my glasses up? Thank you.
Yep.
Am I able? What are they telling her?
I can't hear.
I don't know. It's just,
And then her response is telling.
You've been informed of what you're arrested for?
no.
Being arrested for first-degree murder, arson, burglary, and tampering with a deceased body. Okay?
Is there proof of that?
Yes.
Compare and contrast the two people in this case, ladies and gentlemen, based on all the evidence that you have. You determine credibility. If you believe that the shy, meek, mild defendant that you saw testify on direct, with all her social anxiety, just didn't have it that day, and her response was because she had a battery in her hand? Does that make any sense to you? The defense just got up and said nothing in the jail letters are inconsistent with self-defense. Ladies and gentlemen, go back to the note to flush. I hope you kept the same story. You ain't dumb. I know they're going to trick you. But if you ain't see or do or hear anything, you're cool. You know, don't give in to they shit. Stop right there. This shows how this case has changed. These two, from the beginning, had an agreement that they weren't going to say anything because they ran from the police, because there's nothing consistent with self-defense then, and there's nothing consistent with self-defense now. And it was Baby Joker's fault. It probably crossed your mind to say stuff, but then you going down too. Hosanna Varela accepted her accountability. She described what her role was. She did bring that murder weapon, not to Chris, to the defendant, after he was laying there unconscious. And Hosanna had to listen to that blunt file be shoved into his neck where it sounded like rubber and bone. And she regrets listening to the defendant on that request for that weapon. But that note tells you what you need to do. And ladies and gentlemen, you can go through the other defendants' letters. I added this in after their statements. But there is a variety of things connecting these letters, and they do speak volumes to the fact that this isn't self-defense. There's consistencies throughout them. But specifically, it deals with the situation in 220. That's the letter. There's always been this discussion by the defense that there's other killings. But what we know is the defendant was talking about that, about having all these killings underneath her belt. And specifically, she says, this other bitch can be number 6 under my belt if you catch my drift. There's the discussions of how it's violent, time after time after time. And you get to consider that in complete contradiction to the rehearsed.
Objections.
I'll sustain the objection. Mr. Pirragliam, if you'll rephrase.
To what you got to witness when she testified in order to question she knew.
Again, objection.
All right, I'll overrule the objection.
They're riddled with threats to Hosanna. You can read 220. Direct threats to her and her children. All of that is relevant in comparing these two women. Ladies and gentlemen, finally, they're contending that the defendant did not commit burglary in terms of theft. And we know that ring was taken. It was there on the bed. It was described at length by Lieutenant Cobb. That would have been opened at the time of that fire, that those items were out on the bed. We know that. We know that ring is gone based on Alan Dickerson. We know that ring was gone based on Hosanna Varela. And we know that phone was taken based on the lap and the Google takeout. There was a discussion of the phone being taken out, that she went through his pockets. You also know that Detective Burrows testified at length that when he's watching surveillance video, he sees Chris bring out individual cards at the time of the bar, not a full wallet. It actually supports Hosanna Varela, doesn't contradict her. So the fact she just called it a wallet doesn't mean things weren't taken, because Detective Burrows supported that based on his video examination at the bars. And then, ladies and gentlemen, I want you to just think for a moment about burglary for the arson and the tampering with the body. How in the world are those consistent in any way with self-defense? They're not.
Your Honor, objection. The approach.
Sure. Objections overruled. Mr. Pirragliam, go ahead and continue.
How are any of those crimes of burning a body consistent in any way with self-defense? They're simply not. And you get to look at the big picture, the totality of the circumstances. And then you also get to think, why in the world did the defendant go back to his house on October 16th? Why? She wanted to go look at what she did, where she did it. She went back to the scene of the crime, drove by to look at the place where she stabbed someone 5 times and then went back in to burn his body. And I do want to talk about that, the act of stabbing someone 5 times. Is that at all consistent with self-defense? The number of times. Maybe one time. Defense wants 20. 5 times. And her testimony is that she's not looking in any way, shape, or form, and she's just hitting the same spot. Even though she says, he's kicking, she's kicking. He's pulling, she's pulling. Hands are being moved. You get to use your reason and common sense to just say that's not true. We know Christopher's BAC. We know she had access to just stab him as... He's not moving, ladies and gentlemen. And then you look back at what she did in terms of guilt and regret. It shouldn't get to you if you saved your own life. You wouldn't have guilt, you wouldn't have regret. And then you wouldn't joke approximately 1 month after the fact, ladies and gentlemen. Almost 1 month. That I'll kill a motherfucker for you. Like 6 feet under. When Chris is 6 feet under. And then she says, no joke. This is not a joke. This is a sad reality that there was an unjustified killing for a person that didn't deserve this in any way, shape, or form. Ladies and gentlemen, the people have met their burden beyond a reasonable doubt to murder in the first degree, to burglary, to arson, and to tampering with a deceased body. I'm asking you to find the defendant guilty of all of those crimes as charged, and I appreciate your service. Thank you.